the form of say designs, in the form of trademarks, in the form of say undisclosed information. So these are various things which the people who have brought out these things need to be registered under these things. So because they will get the right for whatever they have invented or whatever they have brought out. If it is a design of a siren, design of a machine, design of a an airplane or of any instrument or anything, or at the same time a trademark, a trademark of a company, a trademark of a particular product, the copyrights ranging from the books to music, audio, all folklore. So there are many other invisible properties which are there, and these are called intellectual properties. Now, to see that these properties, what you call, come into the regular mainstream and get acknowledged by the society and by the authorities and by the authorities and by different institutions, and so and also to see that this any type of intellectual property need to be commercially exploited or need to be beneficial for the economy or need to be beneficial for the society. So we have to acknowledge these things in the society, and to see that these things are acknowledged, you need a proper infrastructure, you need a proper institute, proper backing for the person who is bringing out his own work, whose invisible property it is. If I have brought about a trademark, I need to be acknowledged. If I have brought out some new product or new medicine or new thing, I need to be acknowledged. I should be given the marketing rights, etc. And all this. So you need a small academician who is bringing out this type of intellectual property. How does he go about? How does he go about in what he call in ultimately say that he is acknowledged and he is acknowledged because of his work and all. How do you go about? So from the point of he's bringing out the particular intellectual property to directed till it reaches the consumer, there is a big gap which is there. This gap has to be covered. For this gap to be covered, you need a lot of technical personnel, you need a lot of support, research support, you need a lot of institutional support. So I think the university is fortunate to have this institute with us to give us a roadmap as to how should a particular person proceed. How can we create a what you call what you call a group of researchers, a group of technical personnel who would be backing up the basic researchers. So you need a lot of training, you need a lot of technical advice, you need a lot of you need lawyers, you need academicians, you need technical experts on the if it is a drug, even if there are scientists, if it is a machinery, you need mechanical engineer. So there are many people who need to be involved depending on the type of intellectual property that is. So basic purpose. So this is one thing. This is one thing. Second thing which is there, after the patent is there, once the thing is copyrighted or patented, how does one go about? How does one go about? What are the social responsibilities of the patent holder or somebody else? There are many large issues which I would not like to go into things. I think these gaps can be filled by the institute like yours, and I feel this should be a good beginning for the people who want to bring out something at the same time reach the final customer or final citizen. So that is very important. So the institute, our idea and innovation council, the idea and innovation, our university, SSIP. So we are making a small beginning now, and maybe we have a long way to go. Long way to go. But since it is a beginning, I think we are grateful to your institute for having collaborated with our institute and our centers for training our children, our academicians. See, basically, we need a lot of other support also. How to benefit it, how to go about so these are certain things which we would like to do. And to help us out and to begin with, we have, I'm grateful to Mr. Kumar Raju for having what you call, for having joined us to put out this program, long-term program for our students, our researchers. I'm Grateful to the university for asking me to introduce Mr. Kumar Raju. He is Assistant Controller of Patents, Designs, Intellectual Property Organization, Mumbai, Rajiv Gandhi Institute of Intellectual Property Management. Uh, he is going to talk about the intellectual property rights and the patents and designs filing. If I understand, patents of all the intellectual properties and filing, that's what I understand. He has behind him over 10 years of experience in the central government office under the patent office, Ministry of Commerce and Industry, and presently he is working as the assistant controller of patents and designs. He is working as a program speaker at the Institute Nagpur, which is only central government national IPR training institute in India. He has completed MTech from IIT Delhi, Bachelor of Engineering from GB Pant Engineering College, and he has delivered many lectures on intellectual property rights in the various parts of the country. So he was deputed by the government for the training at the Japan Patent Office, Japan, on the examination of IPR issues. See, there are plethora of issues when we talk about intellectual property. There are plethora of issues which only the person who is into it would be able to tell. There are issues before your institute. There are issues for the person who has brought out the new innovation. So I think time will tell what are the issues the institute would be what you call catering to us, and what are the issues which need to be catered for the authors and for the people who are trying to find the footing in their innovations and all this. I am grateful to your institute. I am also grateful to Mr. Kumar Raju. I welcome the institute first and Kumar Raju for having brought out on behalf of my university, my my centers, we are grateful. I would like to add one more thing. We have a paper on international trade in our post graduation, wherein we do talk about the patents and intellectual property rights, but there with related to how far this would be useful for the development. I welcome you, sir, for delivering the lecture, and I again thank you and welcome you to take over the session. Thank you very much, sir. Welcome again.
So this is now my voice is visible to you.
Yes, sir.
Yes, sir, it's audible now.
Yes, yes, okay.
And my PPT is also visible, so we can start now.
Yes,
Yes,
sir.
sir.
Okay, okay. So I welcome you again on the behalf of NIPM for today's session. Now the thing is that why the government of India has started this initiated this awareness mission. What was the need? So first thing was very important. Since it is awareness mission to make you aware what is intellectual property and what are the things going around us. So I think there is some issue. Okay. So first of all, I start with one data. This is an statistical data which shows that in India the annual filing of the patent is around 56,000, or you can say 60,000 if you will take on a larger perspective. And on the other hand, The China has the annual filing of 15 lakhs.
Tabii
United
göre. Hadi
States
şöyle.
United States has the filing of 6 lakh. Japan has the 3 lakhs.
Ha?
Okay. And uh, in the view of that, it can be understood that, but in the terms of population, we are next only next to the China.
Bas
And no doubt,
RGNIIPM
we have a very good intellectual brain, very good infrastructure, very good faculty members. All are highly competitive, and they are well versed in their field. So why we are not getting so much of the patent? So it has been assumed that there might be certain
भाई बाहर मत ना कोई दुकान पे
uh,
तेरा निकल
there might be
तेरा
certain
इसका खलीफ
there might be certain things that so that in there is very less application in India. So out of that things, awareness has been assumed as one of the point. So the thing is that uh, when uh, when we will feel that you have the awareness, then we will come to the next step. What are the another possible feasible reason to improve the filing? Okay. So first thing is that, second thing is that there is a definition of intellectual property given by the WIPO, World Intellectual Property Organization. Its head office is in Geneva, and India is also member of this WIPO organization. There are only and through the PCT Patent Corporation Treaty, we will see in the further slides what is this. So it has defined the intellectual property, and it is refers to the creation of mind. Okay, such as inventions, literary and artistic work, designs, symbols, names, images used in a commerce. So when we will go into the little more details, what is invention? Okay. So inventions is something for which you can file patents, and for nothing you can file patents, only for the inventions. And inventions means there is certain technological advancement, there is something certain technical step, inventive step. For that you can file you can file an invention. uh, Starting from one example, Thomas Alva Edison has invented a bulb. Okay. So after inventing the bulb, so he has filed the patent, and in the patent there is, of course, you have to disclose that how you have made your invention. So the person who is working on that field, he has to not to start from the scratch. He has certain information now how a bulb can be made. So now he will put some more technical advancement. He will more
My
some
name is Neeraj.
inventive step. Okay. So and the thing is that other thing is that now come to the literary and artistic work. This is given for the copyright. Design is given for the articles only, and the symbols, name and images which has been used for the commerce, it is used for the trademark. Okay. So we will learn each one of the intellectual property one by one, and all of the above intellectual property has been divided into two parts: industrial property and copyright. Except copyright, everything is industrial property. Okay. Now there are certain difference, as the sir
Please अपना
also
वीडियो स्टार्ट करो प्लीज प्लीज ऑन द
as the
वीडियो
sir as the sir also started saying about the intellectual property difference between the physical and the intellectual property. So the thing is that when we move 30 or 40 years behind, so in that scene there was much importance of the physical property. Okay. How much physical property you have, the more value, more addition on you. But now the today's scenario is completely different. Today's scenario is about the intellectual property, and everything depends on the knowledge, your information, how much intellectual property you have. So the thing is that to be competitive in market, everything is intellectual property in today's scenario. Without intellectual property, nobody can have the existence right now. Everything you are using around you, all are related with the technology or are related with the intellectual property. Okay, so things is that now the time has come to take intellectual property very very seriously. So there are certain differences comparison between the physical property and the intellectual property. Of course, physical property is something for which it passes from one generation to another generation. First thing, second thing is that for any property you have to take the legal right. Okay. The third thing is that it is for unlimited period of time. Now come to the intellectual property. It is given for the limited period of time. Correct. Second thing is that it is intangible. Third thing is that transfer cost is very hard to calibrate. Means if you have certain invention and you think that you want to assign somebody else, you want to give your licensing to somebody else. So it completely depends on your technique, your calibration method, your viewpoint, how you have you can influence other that this is not a part of so it completely depends on you. Okay. On the other thing, on the fiscal asset, it is very easier to transfer. The cost can be easily calibrated because it is decided by the society, it is decided by certain organization, it is decided by the market. Okay, but the transfer cost you have to decide only. Now the for the enforcement of property right, you have to go to the court, and it is relatively difficult because you have to understand, you have to make understand to all the person that he has used my invention. And in terms of fiscal asset, it is relatively easier to get the enforcement right. Now, suppose that there is a common person, there is a businessman, and common person has got the patent. What he will do with it? So common person will might get some incentive in his company, in his organization, or he can apply and he can get some might good job. He can get more social values while filing the while getting the patent certificate. But on the other hand, a commercial person, he will try to license it. He will try to assign his right to other person. He will try to find the person who is working on that field. Since when you file your patent, it has to be published by the patent office. So after filing, everybody can know your invention. So the person who is interested in your field, he can contact you for the licensing, okay, or you can also search for whom you can get the license. Second thing, if your technology is important, you can merchandise it. Merchandise is suppose that you have seen the Apple laptop. In Apple laptop, it is completely related with the technology, and in that technology he has used the logo of Apple. That is trademark logo, and trademark logo can be uh, used when somebody will look at the logo, he will understand that it is the Apple product. So genuinity comes through the merchandise. So one single product, so many intellectual properties. Okay, we will see by one example. This is the data which indicates that the contribution from the Indian ordinary person, Indian origin, or the institutes or the organization is only 18.9%. So there is a very huge gap for the and huge opportunity for the organization and the institutes. Okay, so why is this difference? We will see in the further slide. This is the statistical data. Now these are the number of institutes with the filing number of application. See, Indian institutes come collectively 664 application, and Lovely Professional Universities has 442 application alone. So this university has gained too much of importance in the field of intellectual property. So your institute can also come forward, and he can also become a You can also be in top 10 university, and it will be beneficial to your institute, for the society, and for the all the intellectual property regimes. Now these are the types of the intellectual property. First one is patent, second one is design, after trademarks, after that geographical indications, after that semiconductor integrated circuit layout design, copyright. Okay, and these are not an exhaustive list. Here it has been assuming that intellectual property means something that must have commercial value. Okay, so patent is given for the inventions only. Designs is for the article. For article you can file design registration. Article may be only be hardware, but it may be two dimensional, three dimensional, or more dimensional. Trademark is also there. Trademark is trade name, trade logo, trade symbol, everything comes under trademark. Geographical indication is there. Geographical indication, the thing is that the geographical indication can be filed by not an individual. It can be filed by a community. Okay. Suppose that you say Darjeeling tea. So Darjeeling tea indicates the person, community residing in the Darjeeling. It is not indicating any person. So geographical indication will be filed by a community, not by an individual. And but all other intellectual properties can be filed by an individual. SICL design, now it is gaining more and more importance, because everybody needs faster speeds, information, more information in a single gadget, more safety features. All these three comes to the SICL design. Okay, and after that copyright. So one thing I want to tell you about the copyright. Copyright is the right. So what is it mean? So suppose that you have just written any book, okay, any good book. So just you have finished right now. You have finished writing this book. From that time, you have the right for that book. You don't have to go to the copyright office. Okay. Now, copyright is governed by the Berne Convention. And Berne Convention, the complete universe, the complete world, who has signed the Berne Convention? Okay, so this is a universal right. Your copyright will be applicable to all the countries who has signed the Berne Convention. And although patent is a territorial right, design, trademark, these are the territorial right, but copyright is a universal right. Okay. Now this is an example. This is an Apple laptop. See a single product and how it can be utilized for the five types of patent, five types of intellectual property. For LED display, it required certain technology. For that technology, he has filed the patent. And the unique feature of the body of the laptop, okay, he has filed the design. Apple sign for the trademark. And when you will purchase an electronic item, generally they will give the user manual how to operate this. Since they have created this, they have the creation of this. You are the are the owner of an institute. You are also handling an institute. So you also give the perspective to each and every academics, and perspective of your college to every person who will get you come for the inquiry, or who will get the admission. So since that perspective has been generated by you, has been created by you, so you have the copyright for that also. You don't have to go to the copyright office that I have made this prospect of my institute or this college. So likewise, the copyright, the user manual has been created by the Apple company. So they have the copyright from the right now, from that time only. And another thing is the layout of the integrated circuit design, IC semiconductor design. So these single product and five types of copyright. So this is the brain of a commercial person. How a commercial person is utilizing his intellectual property in more than one methods. Now come to a patent. What is patent? So it is an intellectual property. So for their intellectual property, you have to take the right. So who will give the right? The right will be given by the sovereign body or state. In this case, government of India used to give the right for the patent, and no any state government can give the patent right, and it gives to it is given to for the given to the inventor as an exclusive right. Exclusive right means you only exist. 135 140 करोड़ की आबादी में सिर्फ आप एग्जिस्ट करोगे और कोई एग्जिस्ट नहीं करेगा. नो बडी विल एग्जिस्ट. आपने अपने लिए एक रेड ओशियन बना लिया. उस रेड ओशियन में आपके परमिशन के बिना कोई इंटर नहीं कर सकता है. नो बडी कैन इंटर इनटू दैट एरिना. ओके. You have the 5 types of exclusive right for making, using, exercising, vending and importing. ठीक है. So you can stop anybody from these things. But the thing is that it is a territorial right. If you have filed your patent in India, you cannot stop anybody for commercial exploiting your product in Bangladesh, in Sri Lanka, in China, in Japan, in Pakistan. You cannot stop anybody. For that, you have to enter into that country also. You have to file your application in that country also. Okay. Second thing, ये right is given for the limited period of time. For patent, this is for 20 years of the time only. Okay. So the thing is that you can ask one question that the government of India is giving too much benefit of the inventory, then what the benefit is going to be get by the Indian people, because government works for the public. So in exchange of that, he has to disclose in his invention that how he has made that invention. So after 20 years of time, anybody can make this. Okay. So suppose that I have taken the example of Thomas Alva Edison. He has invented the bulb. So he filed for the patent and he disclosed his invention. And after disclosing the invention, so the next inventor who is working on that field, he will also get he will not to start from the scratch. He has a certain information how to make this bulb. Now he will make some improvement, and he will come for another patent. He will with some technical advancement. Okay. So it is some kind of technology exchange also. So it might be possible that you all are working in any of the technical field or in any of the field. So, and if you are also doing some technical advancement in your work, so for that technical advancement you can file your patent application also. Okay, these are the small things. Patent can be as simple as, it cannot be a very big giant. It just if you have a technical solution. Okay. So this is a cup. This is works on the siphon effect. When you will press it, the liquid will come out. This has been patented. This has been patented technology. This is also a trampoline, and this is has been got the patent in 1945, and now it is using in the Olympic event. Okay. This is George Alfred Dippening. He has made the first efficient pankha pulling machine. Civil engineer of Calcutta. Okay. In 1856, it is the first patent taken by an Indian. Now there are other scientists, foreign scientists, you know their names: Thomas Alva Edison, Alexander Graham Bell, Wright brothers, Louis Pasteur, Alexander Fleming, and these are their inventions, and they have earned millions and millions of dollars from their invention. So it is worthwhile to say that a single product, a single invention can change your life. These are the another famous Indian inventors who has also earned millions and millions of dollars. This is nano car. Okay. This is the first car technology made by the Indians. Okay. This is hepatitis vaccine. This is also made by the Indian inventor. This is prosthetic leg. And after getting the patent, he also exported his product outside India while filing patent in that country. Okay. So when you make product, if has usefulness to the public, okay, There is one also example of you have seen red light. There are generally red light signal. Three signals are there: red, green, and blue. Red, green, and yellow. Okay, that technology has also been patented. That technology is the life-saving technology. Millions and millions of lives has been saved by that technology. And in the future also, it will save millions and millions of life. So a single invention and too much usefulness for the public, too much usefulness for the society. So invention can be looked into that way also. Now this is the patent filing system. So I was saying that patent is a territorial right. So if you have filed your application in India, so and you want your application to be filed in US, in Europe, so what can you do? So there are two methods to enter into that country. First one is PCT method, another one is convention method. So the country who has signed this treaty, Paris Convention Treaty, PCT, okay, and no, sorry, Patent Convention Treaty, PCT. Its head office is in Geneva, and India is also member of this. So when you file your application through ISA and you have chosen India as a PCT, so you have 31-month time to enter any of the country who has signed this treaty PCT. Okay. So you can enter into any of the territory of different countries. Second, likewise, there is Paris Convention also. It has been signed by almost 190 countries, and you have filed your application in India. So there is timeline of 12 months only. In PCT, it is international filing. So timeline is 31 months. In conventional filing, timeline is only 12 months. Okay. And this is the ordinary. When you are Indian inventor, you can file your application in India also. So there is a file the provision. You can also file a provisional specification if you think that your work has not been completed, and it will completed within 12 months. So you can file your provisional specification, and after 12 months of time, you can file your complete specification. Okay. After that, it will get published, and after publication, you will get the first examination report. And first examination report, you will compliance by the, you have to give the reply of the first examination report within 6 months, and you can take extension of 3 months more, so 9 months of the time. And after each, if all the objection will be met, then you will get the grant. Otherwise, hearing will be done and all objection met, will be grant. Otherwise, no, these are the minimum forms you have to fill for your application to be filed. First one is form 1, in which each and every details of the application and applicant has to be given. In form 2, you have to give the details of the invention, like title, background of invention, particular of drawings, brief description of drawing, brief description of the invention, claims, abstract, and drawings. Everything you have to given in the form 2. Okay, and see, it is a big document. Up to 30 page, it is 10 page, 20 page document. So each and every step should be written in a strategical way. Since patent is given to the claims only, what is your claim? Suppose you are claiming a thermo flask, okay, and you are saying that all the previous thermo flask which has been invented earlier, he can uh, he can put the originality of fluid for 6 hours. Now your thermo flask is taking the fluid original condition in up to 12 hours. If it is warm, it will be warm up to 12 hours. If it is cold, it will be cold up to 12 hours. So that is your claim. So you have to give all the essential technical feature into the claim, that which type of insulation, what are the technology you are uh, going to give, so that you have achieved this final outcome. Okay, it has to be given into the claims, the drawing should be clear, and all other aspect has to be that has to be supported to the claims only. Okay, now form 3 is there for the filing of similar patent outside India. You have to give the form 3. Form 5 is the declaration as to inventorship. Formatting is that for the request of examination. Okay, see the fees is for the natural person or individual, 1600 for the individual, 8000 for the company, and for formatting fees is 4000, and for other it is 20,000. So there is minimum requirement of 5600 only. So by this amount only uh, uh, you will get the patent certificate. This is the minimum amount. Now this is the final e-filing portfolio. When we will click on this e-filing portfolio, this link will be open and you have to register, and there is the guideway how you can file your application. Okay, patent application, design application, trademark application. Okay, and now the government has started the provision of expedite examination also. So the thing is that if you think that your work if office works on the principle of first come first serve. Okay, so your office works on the principle of first come first serve. So thing is that if you want that your application should be expedited early, so you have to, there is certain provision under which your application can be expedited. If you are a startup, if you are a small entity, if your applicant is a female, if you are a government department, if you have chosen India as a ISA or IPA and PCT, or if there is any agreement between Indian Patent Office and Foreign Patent Office. Okay, so this is the processing examination process. First of all, your work will be examined and you will get the first examination report, and you have to give the reply within 6 months of the time normally, and you can take 3 months of extra time. After that, hearing will be there, and if all the objection met, it will be granted, otherwise it will be not granted. So this is the chapter 5 of Indian patent, and it is very important chapter. Okay, and all the important things has been mentioned here. How to draft your invention. So it has to be fully and particularly describe the invention. All the parameters has to be fully and particularly described. Okay, and you have to further disclose the best method to perform the invention. This is very important. Okay, and you have to define the scope of the invention from the very first day of your filing. अभी आप कह रहे हो कि आपने एक थर्मो फ्लास्क फाइल किया, नाउ आप फिर बाद में अमेंड करके कह दोगे कि थर्मो फ्लास्क जो है वो इलेक्ट्रिकल पावर सोर्स के थ्रू वो 12 आवर्स वो हीट कर रहा है, so that will not be allowable. So from first day of filing you have to define the scope of your invention. Okay, and all these things are, it should need an abstract drawings, all things, it can be self readable, and this user manual, patent user manual, is easily available in the Google on the PDF. I request all you to download it from the Google, and you must read this at least section 10. It is very important for the patent filing. This is a technical examination for invention. Office will check for the novelty and inventive step with respect to citation, and he will prepare the detailed report. So see, this is an pencil. Okay, and the claimed invention is that a pencil comprising a core, okay, which is made of a graphite and clay, okay, and a wooden shaft having a polygonal cross section. This is the claim. Now, how novelty can be judged? An invention should have novelty and inventive step. If it has no novelty or no inventive step, then your application will not be granted. Okay, so it should have both novelty and inventive step and industrial applicability. All three things it should have. Now come to the first. For the novelty, only a single document is required. And prior art is that from the date of your filing, before the date of your filing, आपके एप्लीकेशन फाइल करने से पहले के डेट में वो टेक्नोलॉजी किसी पब्लिक को पता नहीं होना चाहिए, वो पब्लिक के डोमेन में नहीं होना चाहिए. सो दैट इज द मीनिंग ऑफ नोवेल्टी. अगर वो पब्लिक के डोमेन में है, so it means that is the novelty destroying document. Okay, so prior art is that there is a pencil which comprising जिसका कोर ग्रेफाइट का बना हुआ है एंड क्ले एंड वुडन केसिंग हैविंग हेक्सागोनल क्रॉस सेक्शन. ओके, तो इसका ट्रायंगुलर है, स्क्वायर है और ये हेक्सागोनल है. ठीक है, तो इट कैन बी अज्यूम दैट द पर्सन हु कैन मेक एन हेक्सागोनल ही कैन ऑल्सो मेक अ पॉलीगोनल सेक्शन. ठीक है, so this application has no novelty. Now coming to the inventive step, for that two documents are required. In one document the pencil is made of a core of a graphite and clay. In other document the cross section is hexagonal cross section. So by the combining of these two teachings, a person skilled in the art can arrive to the solution. Okay, now these are the basic timelines. Provisional to complete specification 12 months, request for examination 48 months, FER reply 6 months, Form 3 6 months, Form 5 1 month time of the filing. These are the from the date of the filing. This is also withdrawal. You can withdraw your application within 15 months. Hearing submission will be within 15 days after the hearing. And pre-grant opposition can be filed by any person before the grant of the application, but after publication. Because after publication you will know about the application. And post grant opposition, it can be filed by the person interested, it cannot be filed by anybody. So the person who is working on that field, post grant opposition can be filed by only them. Come to the design. So the thing is that suppose there are two technology and two different company but the same technology, so the customer will come to any company, he will go to the any system. But if one is clever, he can make the good design of that. Now today's scenario, today's world is the fashion world. Everybody needs the better design and the latest technology, latest design. All things are is mattering today's. So office judge the design by on the basis of two things. First of all, that should be a finished good. Second thing is that it has to be solely judged by the eyes only. Okay, there is no another method, and it is design. It will be governed by the Design Act 2000 and the Design Rule 2001. And the terms of design is 10 years, and it can be extendable up to 5-year modes, means 15 years it can be given. These are the few industries which works on that only, that solely that design principle only. And this is the only selling point, unique selling point in the design industry. Okay, these were the individual, these were the sets, the ornament industry works on the principle of design only. This is the dinner set, cup set, this is sofa set. It can be sold individually, but all works on the principle of design only. I think there are 300 400 people have participated in this webinar. All have different types of pen, different designs of pen, all have different design of purse. So the thing is that it must be new or different. These are the requirements to file the ordinary application. 1000 rupees for the individual and 4000 for the company, and you have to file in the form 1, in which each and every details you have to give. And power of attorney, if you need power of attorney you can file, otherwise it is not compulsory. And if you are a small entity or a startup, You have to give the documentary evidence that you are a small entity or a startup. There are so many industries which has started on the basis of design registration only. New startups. Okay, this is a teapot. This has recently got the design certification. This is the another device which has also got the design registration. So similarly in the patent in design also, when you will get the first examination report, you have to give the reply within 6 month time, and there is further 3 months extra time. So total 9 months of the time you have to file the first examination report, and the terms of its design is initially for 10 years and it can be extendable up to 5 years more. So total time is 15 years, but the thing is that you have to pay renewal fees each and every year. Okay. Now come to the trademark. So the trademark includes trade name, collective marks, certification marks, taglines, slogans, shapes, sound marks. You have seen the IPL match, okay, in which you have heard the particular type of sound. That is trademark. You have in Kon Banega Crorepati, in when you will open your computer window, you have heard a special type of sound. This is also a sound of the special type. This is also a special type. All are the trade marketed sound. Okay. So slogans, any name, commercial name, article, symbol, but it should not be descriptive. Trademark should not be descriptive. Okay. And if there is any technology, so that technology can be trade marketed also, so that it can be reached to it can gain national, regional, international value. Okay. So how we will identify that this product is trade marketed, registration has been done or not? So when you will see the symbol R with a circle, it means the trademark has been registered, and TM means the trademark has not been registered, it is unregistered, and application is still pending, it might also happen. So while filing trademark, what should you have to do? It should be honestly adopted. Okay, you have to check the similar trademark which you are filing, and before adopting a new trademark, it is advisable to search conducted and evaluated, and to avoid the unnecessary litigation. You have to make a proper search. Okay. Now the trademark registration is optional. It is not compulsory, but the registration has a certain advantages. The advantages is that it is initially registered for the 10 years and it can be further renewed indefinitely. So when you file for the trademark registration, it will be get published after publication, national, international, regional, in each and every zone. Your trademark will be renowned. Office will stop imitation, that similar or same trademark logo will not be should not be used in practice. So your product will be authenticated, your product will be more genuine. Okay, so that is the benefit of getting trademark. Now come to the copyright. The first thing is that no idea can be copyright. So what thing can be copyright? If there is any literary work, if you have written any good work, if there is any artistic work, dramatic work, musical work, sound recording, cinematographic film, all this can be get the copyright. And the best thing is copyright, that you don't have to go to the office. You have, if you have written any poem, any book, and you have made any dish, from that time only you have the copyright on that. Okay. So you cannot use that product by the permission of that person. That is the benefit of the copyright. Now these are the some literary and artistic these are the some name of the creators. Copyright is given only to the creator. Okay, the author will get the literary work, music composer music work, artist will get the artistic work, photographers, producer, and the thing is that it will goes to the creator only. Okay. Now the very important point is that the lifetime is the life of the author plus 60 years. So if you have written any good book, so royalty will given to not you, your next generation. He will also get the benefit up to 60 years. So that is the importance of the copyright. These are the fees: 500 for the literary work, 2000 for the artistic work, sound recording is 2000, cinematographic film it is 5000. Now SICL design, semiconductor integrated circuit layout design. So these are the forms: LD1, LD2, layout design 1, layout design 2. So in layout design 1, this is the design. Okay, you have to give the design in the application, and registrar may accept your design or may refuse your design. If we will accept it, it has to be advertised within 14 days, and you have to wait up to 3 months. If no opposition will come, you will get the certificate. If opposition will come, it will be accepted and hearing will be granted. And on the basis of evidence, final decision will be taken. And the fees is the 5000 for filing the layout design. This nowadays very less application has been filed in this field. Okay. Now come to the next point, that is geographical indication. So as I told you, this is given not to an individual, it is given to a group of a people. So if there is certain thing has origin in your community, is originality, is new thing, so you must file the geographical indication in the Chennai office. When you will file there, the office will call the group of the people, and will have to give the presentation, and they have to give the sufficient evidence that this product has the originality from your community. Okay. This, for example, this is the Darjeeling tea. This is Makrana marble from the Rajasthan, Madhya Pradesh Ratlam Sevai, Kanchipuram silk from the Tamil Nadu, Maghi pan from the Maga, Shahi Lichi from the Bihar, Nagpur ke संतरे, Kashmir saffron. Okay, so these are the few examples. Now there are certain points which has to be remembered when you file your patent. So first thing is that first you have to protect. After that you can publish.
एक मिनट को मैं चेक करता
So
हूँ
the
आपका
thing
भी
is
जमा है
that how to protect your file your application to the patent office. You must not get go for the publication first.
क्या नाम से है वो बिल क्या नाम है
जब आप पहले उसको पब्लिश कर देंगे तो आफ्टर
मैग्नेशन
पब्लिकेशन
क्या
क्या होगा? That document will become
ये वाला
that
है क्या
दिखाओ ना बिल दिखाओ।
that document will destroy the
कौन सा
novelty of
वाला
the application.
अच्छा हाँ यही है।
हाँ
Okay.
फोटो भेजो मेरे को
यही फोटो है, यही होगा हमारी फोटो।
So that will destroy the novelty of your document. So first thing is that go to the patent office, file your application. Okay, before publishing your invention. It is territorial right. So if you have filed in India
इसके
and
बैक साइड में फीता नहीं लगा हुआ इसमें सर जी
you
छोटा
need
कैसे
more
लगेगा
protection,
बैक साइड का तो अपने तो फीता है ना
you can go to the another country also. You have to file in other country, and
अरे सर जी
registration
लेकिन
will be
कंधे
done
में
by the
ऐसा
government
है
of
इसके
India, not
अंदर
by the
ये
state
नहीं लगा
government.
ना
And right
कंधे
is
में
given
देखो
for
वो
the
आ गया
limited
आपका
period of time, and
एक
no
मिनट रुको
automatic
इसको
relief
पहना
is there,
इसको एक मिनट रुको इसको पहना
and
मैं
renewal
पहना
fees you have
अगर
to
मैंने
pay.
पहना क्या
आपको renewal fees देना होगा IPR
ना
को लाइव करने के लिए. Appointment of patent agent is not
मैं
compulsory.
रेट रेट आपको रेट करवा
If you
दूंगा
have
मैं रेट रेट
self-sufficient
करवा दूँ
knowledge,
रेट का
so
उसमें
you
मैंने
cannot
एक बार मैं सिर्फ तो पैंट से
document.
पहना के
You
बताता हूँ
can
इसके लिए
self-sign
आपको
and file the document.
अरे वो गलती से अरे
These are
गलती हो गई
the
थी वो
government initiatives
स्टाफ
which
से
has
मैं
been
बोला भी
taken,
था उनको वो
and
चेक
this
किया
is
ना
the
उन्होंने
career
रंग करने गया
opportunity.
वो गलती से जाने के लिए
If
उसने
you are a
डाल दिया
engineering graduate or science postgraduate, you can become an examiner of patent and design. If you are a law graduate, you can become a trademark and geographical indication
आप बताओ
and
कौन
copyright
कहाँ दिक्कत
examiner.
है
All these are gazetted officer
अंदर में
post.
क्या
All these are respectable post. You can also become a patent agent if you are a science graduate. You can also become a trademark agent if you have a law graduate.
एक बार
In
है ना आप
RF,
माल चेक
SRF,
कर लो
in patent
ठीक है
facilitation center,
जो
you
जो
can
खराब
work.
माल है ना
You can also work in a
वो उसको
patent
साइड में लगा
litigation and
दो उसको
other
साइड में कर
opportunities
दो
in
ठीक है
private sector. Okay.
हाँ उसको साइड में कर
This
दो,
is
उसको
our
पार्सल लगा दो.
Rajiv Gandhi Institute address. And for future, if you have any issue, you can
हाँ
contact
हाँ हाँ
our institute.
हाँ जल्दी.
Okay. And recently, we are arranging the offline program for 22 to 26 August. So if you want any further info regarding to know about the
वो
patent
दूसरे
specification and
पार्सल में
filing,
आएगा ना,
you can contact to our
तो
institute.
अंदर ब्लैक में प्रिंट ना,
This is
डिजिटल
the
प्रिंट.
fees is to 2,000 per day
हाँ
per
वो आपका
participant.
नेक्स्ट
To
पार्सल में
minimum
आएगा.
4,000 is
उसमें
for
पिक्चर
if
आपको,
you want concession, there
हाँ
is
उसमें पिक्चर
50%
लगा हुआ है.
concession also.
मैं देखो फोटो
For
भेजता हूँ आपको.
students, official from the college, ladies participant, owner or the
मैं
employees.
आपको बता
Okay.
देता हूँ पिक्चर.
And this is thank you.
ये देखो, ये ना ऐसी आएगी, मैं आपको व्हाट्सएप किया हूँ.
So
ठीक है, तो उसमें आगे का
if you
फीचर
have any
लग ही नहीं
question,
सकता.
you must ask.
फीचर कहाँ लगेगा, ऊपर का तो लॉक है ना इसमें, ये डिजाइन ही ऐसी है. फीचर रहेगा, ये देखो, तो जो फीचर है और ऊपर के अंदर ये ऐसा ब्लॉक पैक ही रहेगा.
Hello,
Yes.
sir. Dr. Milind this side.
Yes.
I just want to know about that we can secure or copyright our code or not. Program I am talking
No,
about.
no, no. You copyright you can do because anything you are the creator of that code, so you have the copyright on that. Okay,
ये
but you
पैटर्न मिल
cannot.
जाएगा, ये पैटर्न मिल
No, no,
जाएगा,
sir, no,
पैटर्न
sir.
दूसरा
You
डिजाइन आएगा.
cannot get
मैं
the
आपको
patent.
फोटो भेज देता हूँ.
Okay, fine. Thank
Okay,
you.
ठीक. So you can read more about the section 3K. There are computer related inventions. You must read section 3K regarding your software issue. So when there is also a guideline provided in the IP India website,
Okay.
and you will get more and more information regarding how a coding and algorithm and mathematical program or any business model can be patentable under what are the conditions. You can go through in the CRI guidelines, computer related invention.
CRI guidelines.
Yes.
Okay. Thank you, sir.
Okay.
और किसी को कुछ क्वेश्चन पूछना है?
रजिस्ट्रेशन और ट्रेडमार्क रजिस्ट्रेशन, कॉपीराइट रजिस्ट्रेशन, ये कम्प्लीटली पूरी इसकी ट्रेनिंग लेनी हो तो इसका कोई कोर्स वगैरह है क्या सर?
अभी मैंने लास्ट स्लाइड दिखाया था 22 ऑफ अगस्त से 26 अगस्त को ऑफलाइन क्लास है हमारे. आप उसमें पार्टिसिपेट कर सकते हैं. और सेकेंड थिंग है कि आप ये भी कर सकते हैं. आप ऑनलाइन क्लासेस भी होते हैं. आप ऑनलाइन क्लास भी ज्वाइन कर सकते हैं. एंड सेकेंड थिंग ऑल्सो आपको ये पूरा एक बार में तो आप नहीं सीख सकते हैं बिकॉज पेटेंट के लिए, पेटेंट और डिज़ाइन के लिए थोड़ा सा टेक्निकल नॉलेज होना चाहिए और ट्रेडमार्क के लिए थोड़ा लॉ का नॉलेज होना चाहिए. So one by one, when you will get into details, you will understand that how you can get the benefit of all the intellectual property. आप हमारे यूज़र मैनुअल को पढ़िए. पेटेंट का अलग यूज़र मैनुअल है, डिज़ाइन का अलग है, ट्रेडमार्क का अलग है, कॉपीराइट का अलग है. You will get the user manual complete in our in Google. You will get it. The guideline we have provided it in the PDF format in a very nice presentation. So you will get it. So it don't think about too much. Just start by one. Only one single thing can create a difference. So make a single thing, make a single technology, and start taking more and more intellectual property from that single thing. As I shown in the example of the Apple laptop, one single product, five intellectual property. So running separately for the different thing, you have to come with a single thing and more intellectual property, more creation of mind in that thing only.
So I have one question,
I mean,
Mr.
I want to
Hello.
create my profession about registering trademark and copyrights,
Hmm.
like law professional do it. So I was asking, what is this any course that any kind of
Yes, yes.
professionals who
There
registered
will be
for the
there
people?
will be course, and if
Uh, this
any,
kind of question I was
yes,
asking
yes,
for.
you visit, you can visit our RGNIIPM website. So if there will be any course, it will be floated there on the Facebook and Twitter. We have the also account. If there will be any course from the training institute, you can get, you can know from there.
I have one
Okay.
question,
Yes.
Mr. Rajuji.
Yes, sir.
Hello.
Yes,
Yeah,
sir.
the question is if any patent has to be filed, it has to be done in individual countries, or if is there any provision for one patent to be applicable to all the countries or anything? It has to be individual countries.
Yes, yes, sir. It is a territorial right.
It is
So if you have filed your application in India, you will
uh,
get all the exclusive right in India only. If you want to get the benefit in China, in Japan, in Korea, in Pakistan, in any country, you have to file your application individually.
and
Because it is the thing is that when you see, when you look technology in terms of legal angle,
hmm,
so patent means you looking the technology from the legal angle, from the law angle, and the law is different for the different countries. India
yes,
is in India there is just we discussed section 3K, no, but in some other countries software and coding all these are allowable, but in India it is not allowable. So
and
all different countries has their own laws, their own method of judging the technique, novelty and inventive step. So that's why it has to be filed in different countries for getting the benefit in that country.
sir, the pre-existing clause which is there for any type of this intellectual property. So this
Hmm.
pre-existing clause is examined only in our country, or then it is examined for based on all the countries whether it is
Yes, yes,
pre-existing.
yes. Universal examination will be done. So if there is a very fair chance, if you got a patent in India, so if you will file your application in outside India, so there is a very fair chance that you will also get your patent granted in other countries also. Or you have filed your application in Europe and they have granted your application, so there is so much fair chance possibility that you can get your patent in India also.
And the time span for ultimately till you get the patent rights and all those
It
things is the
depends. It
same across
depends
all the
on the.
countries.
No. Each country has different timelines
Okay.
because it depends on the pendency also how much pendency is there.
Okay.
So on the basis of that only. And second thing is that also if lesser objection will be there, more faster processing. If more objection will be there,
Certainly.
certainly.
It all depends on the type of thing
Yes,
you want
yes,
to get it registered.
yes,
Okay.
yes. Correct,
Yeah.
correct.
Sir, myself Praveen Kumar.
Yes,
Uh,
sir.
Sir, to become a professional in IP, any special course or things is required, or we can start based on our knowledge. As I am in advocate.
Okay, so you are a law graduate,
Yeah.
so you can become if you have your registration in bar council, so you can become a trademark agent, copyright agent, and geographical indication agent. But you, if you want to work in the patent and design agent, for that you should have science postgraduate or engineering graduate degree, and
Okay.
you have to give the patent agent exam. After that you can become you can also work in this field also, but for the patent agent, no, trademark agent, no need for any exam. If you have registered in bar council, you can apply for you can go for the trademark and copyright agent.
Thank you, sir.
Anyone else? और किसी को कुछ पूछना है?
Trademark can be done individually or there is compulsory need of trademark agent.
आप खुद भी कर सकते हैं, कोई एजेंट का जरूरत नहीं है आपको। कॉपीराइट के लिए एजेंट का जरूरत पड़ता है, ट्रेडमार्क के लिए कोई जरूरत नहीं, इंडिविजुअल कैन ऑल्सो फाइल।
Okay. To conclude this session, I'd like to thank Rajiv Gandhi National Institute of Intellectual Property Management for collaborating with VNSGU and co-create this learning environment for all our student and faculty members. I'd like to thank our speaker for today's session, Mr. Kumar Raju sir, for enlightening us on the topic and sharing your knowledge that will be useful for all of us. I thank Professor Dr. S. Srinivas Rao sir for mentoring us at every stage to make this event successful. And last but not least, I'd like to thank all our participants and our Idea and Innovation Management team for your support.
So, okay, thank you, sir. Thank you very much for having a patiently listening to that for the today's webinar. And I welcome you all and wants to give a thanks from RGNIIPM, and I request all the participants to fill the feedback form. It is very, very important to get the certificate. And if it is possible to fill it is as soon as possible, so you will get the certificate by tomorrow only. Okay. So thanks a lot for having this.
Thank you.
Thank you, sir.